So what is medical malpractice? When I was practicing nursing, I thought I knew it, and I think many of you out there also believe that you know what that means. But today I'm actually going to give you the definition so you can know exactly what medical malpractice is and what it means for you in your practice. Medical malpractice is a type of negligence that pertains to healthcare professionals. It occurs when a healthcare professional deviates from the standard of care required in his or her profession, and that deviation results in injury, death, or damage to an individual. So, in a medical malpractice claim, you are taking care of a patient, for example, and say you did a dressing change and you did not use appropriate infection control procedures, and the patient walked away with a really bad infection and had to get some type of amputation. And they decide to sue you in court, the nurse, because of the dressing change. And their argument would be the dressing change that you performed fell below the standard of care. So in order for them to bring that lawsuit, they have to prove 4 elements: duty, breach, causation, and damages. All 4 elements have to be proven in order for the patient or the plaintiff who's bringing the medical malpractice claim to be successful. The first element, duty. They just have to prove that there was a provider-patient relationship between you and the person suing, or if it's the person's family member, between you and the patient that you took care of. Breach. They have to prove that you breached that duty. And what does breach mean? It means that your actions fell below the standard of care. Now, we're going to pause right here just to discuss what is the standard of care. The standard of care is what a reasonable, prudent person who practices your same profession would do in the same or similar circumstances. What a reasonable, prudent person who practices in your profession would do under the same or similar circumstances. So we have duty. You took care of that patient in the med-surg unit. It was obvious you were assigned. There was a patient-provider relationship because you performed the dressing change. The allegation is that you breached that duty because a reasonable, prudent nurse would not have conducted the dressing change in the manner that you did, so they're saying that you breached the standard of care. Let's take another pause. How do they prove that in a court of law in a medical malpractice case? Well, the way that that is proven is through expert witnesses. The person who is suing you in court, whether it's the patient or the patient's family member, would hire an expert witness to evaluate the medical chart and form an opinion on whether your care breached the standard of care. So that expert witness would need to be a person who practices your same specialty and is qualified to give an opinion on your care. And that gets really complicated, so I just simplified it. Your attorney, defense attorney, will also hire an expert witness to also offer an opinion to defend you in the medical malpractice case to show that your conduct did not breach the standard of care. So those opinions will be what is considered, if this case goes to court and is heard by a jury, by the jury in deciding whether there was a breach. So we're still on our example of you taking care of a patient, doing a dressing change, the patient getting an infection, having to have an amputation, and they're arguing that you didn't use proper infection control procedures, you breached the standard of care. So if the plaintiff or the patient is able to prove that you did breach the standard of care, it doesn't stop there. They now have to prove that your breach of the standard of care actually caused damages. So causation, for example, you not washing your hands, and they found for some reason that you did not do that before you did the dressing change. They would have to prove that your failure to wash hands actually caused the damages, which are the infection, and the infection, which caused the amputation. Let's say that one more time. So, if one of the things they found that you didn't do correctly was your failure to wash hands, their expert would try to make an argument that your failure to wash hands introduced some type of pathogen into the wound, which caused a severe infection necessitating an amputation. The defense on the other side might say, well, no, that wound was already infected. Or my client wasn't the only one doing dressing changes. The patient was actually doing their own dressing changes as well. So how can you say that this one breach, which is the failure to wash hands, actually caused this person to have an infection in that wound and end up with an amputation? Do you follow me? I hope so. So, duty, breach, causation, damages. All four have to be proved. Even if you prove some type of causation, it has to be damages in the case in order for the case to be successful. So, for example, say if the patient caught you changing the dressing and you didn't wash your hands, and they went home, their dressing healed, but they kept thinking about it. That woman didn't wash her hands, or that man didn't wash his hands when he changed my dressing. He wasn't supposed to do that, so I'm going to sue him. Well, what are the damages? If there are no damages, then the case will not be successful because you have to prove all four elements.